Hey guys, today we are going to talk about the oath and affidavit. These are two documents that have to be filed within 14 days after the originating summons and the statement has been approved. You can watch my earlier video on the originating summons and the statement. Rule 2082 of the Family Justice Rules provides that the statement, which is filed together with an originating summons for the grant of probate or for letters of administration, must be verified by an affidavit of the applicant. The supporting affidavit under Rule 208 of the Family Justice Rules shall be in the prescribed format in Form 225 of the Practice Directions. The oath is a simple one-page document signed by the executor before a commissioner for oaths, which essentially states that the executor will faithfully administer the estate and effects of the deceased by paying his debts and distributing his estate according to the will, and that he will render a just and true account when lawfully required. Now, this is what the oath looks like. The supporting affidavit must exhibit the statement, which the statement is essentially a court document that is populated with particulars of the deceased, the executor, and about the will. And the supporting affidavit must exhibit the statement which was filed together with the originating summons. And the statement is generated by the electronic system. And the statement has to be exhibited in Exhibit 1 of the affidavit. The certified true copy of the will and the death certificate of the deceased have to be exhibited in Exhibit 2 of the supporting affidavit. When preparing the supporting affidavit, especially for those of you who are doing DIY probate, it is important to note the order of the exhibits I just mentioned. You must have separate exhibits for the different documents. Some people who try to save money and combine all the documents into one exhibit, just remember this, it will be rejected. Now, there is an Exhibit 3, and this is only if the schedule of assets can be completed in time. That means within 14 days of approval of the OS. This is usually the case where the executor knows all the assets of the deceased. For example, he knows that the deceased owns one HDB flat, one UOB bank, one DBS bank, and that's all the deceased has. And the lawyer can simply populate the schedule of assets in the online system. Okay, the HDB flat known as block whatever, Tampines Street what. The monies in UOB bank account number 12345, and together with the balance $50,000. The monies in DBS account 12345, the balance $27,000. If the executor knows all the assets of the deceased and there is no need to write to all the institutions, the banks, the insurance companies, the brokerage companies. This is called due diligence. Basically, if an executor goes to the probate lawyer with the will and says, I don't know what assets the deceased has, then the probate lawyer has to do this thing called due diligence, which basically involves writing letters to all the banks, all the insurance companies, all the brokerage firms, UOB Kahan, Maybank, Kim Eng, CDP, whatever, to inquire if the deceased has an account or insurance policy with them. This is a very time-consuming process. So if the executor knows all the assets of the deceased, the probate lawyer does not need to write to any of these banks, and the probate lawyer can immediately populate the schedule of assets with the assets. So if the schedule of assets can be populated within 14 days of approval of the originating summons, okay, the originating summons is approved on, let's say, T, okay? you have to file the supporting affidavit and the oath T plus 14 days, okay? If the executor knows all the assets and the SOA, Schedule of Assets, can be populated at the same time, then there would be Exhibit 3 to the supporting affidavit. So on T plus 14, you have to file the oath and the supporting affidavit, which has Exhibit 1, which contains a statement, Exhibit 2, the death certificate and the will, Exhibit 3, the Schedule of Assets. If, as I mentioned, the executor does not know the assets of the deceased and requires the probate lawyer to write to all the institutions, then the supporting affidavit must be filed, still must be filed within 14 days, but it contains only 2 exhibits, which is basically the statement in Exhibit 1 and the will and death certificate in Exhibit 2. And then when the institutions, when the banks, insurers, securities company reply at a later date, telling the probate lawyer, say, no, the deceased did not have an account with us. Yes, he has an account. These are the details, the account number, the balance, or that. In such a scenario, where the institutions have to reply at a later date, for example, 2 months, 3 months later, and the schedule of assets can only be populated 2 or 3 months later, then the executor has to affirm a supplementary affidavit which exhibits the schedule of assets, and then after that probate can be obtained. Practice Direction 63.4 of the Family Justice Practice Direction states that the supporting affidavit shall be filed using the electronic filing checklist within 14 days after filing of the originating summons. In practice, the oath and the affidavit are filed together within 14 days of the OS, as I mentioned earlier. OS is T. You have to file it by T plus 14. So thanks for watching this video on the oath and affidavit for probate applications.